Hello and welcome to another episode of Banking Matters. I'm your host, Elizabeth Holtrop, and today I'm very excited to be joined by attorney Sarah A. Samuel. Sarah works in Texas, where she works for Hirsch & Westheimer PC, located in Houston. She practices civil litigation as a partner at the firm. She currently serves on the board of directors of the Southwest Association of Bank Counsel. She represents state and regional banks throughout Texas. She regularly handles cases involving check fraud, wire transfer fraud, account fraud, commercial and consumer account disputes, special assets and loan collections, foreclosure and deficiency suits, construction loan and lien disputes, turnover receivership disputes, and record request disputes. And I'm betting we have bankers listening in here who are nodding their heads and understanding that those can be complex issues that we certainly appreciate your legal input on. Today, though, we are happy to talk specifically about subpoenas. Sarah, thank you so much for being on the podcast, and thank you for joining us to talk specifically on this topic.
Of course. Yeah. Thank you for having me. I'm honored to be invited to contribute to this program. I've taken a listen to a couple of the other podcasts, and it's just a wealth of information. So it's much appreciated, and I'm happy to be here.
Awesome. I do know, Sarah, you want to read a legal disclaimer, which we absolutely support on the podcast and on anything else Compliance Alliance produces. Working on a team that is comprised largely of attorneys, we certainly understand when you got to have a disclaimer. So go ahead and read that, and then we're going to get into the details of subpoenas.
Sure. So this is for general informational purposes only. I'm an attorney, but I am not your attorney. The information shared here is not intended as legal advice, and you should consult your own qualified attorney.
With that said, folks, you've had the disclaimer. So getting into the heart of what we're going to talk about, to start, can you give us an overview, especially for bankers newer to legal-related topics? What sort of situations would a banker expect to receive a subpoena on a day-to-day basis where, maybe they're just sitting in their office minding their own business, a subpoena walks through the door? What are situations where that might happen at a bank?
If I may quip really quickly, a banker should not be receiving a subpoena if the subpoena is done correctly.
I love that you put that right out there. I love that.
Yep. Right. And if a banker does receive a subpoena, take that straight to legal. Yep. Subpoenas are required to be served on the registered agent of the bank. That's Texas law. Yep. If the bank, for some reason, doesn't maintain a registered agent in the state, then the bank may be served through other legal process, and that under the Texas Civil Practice and Remedies Code, it provides that a president or a bank manager can be served, but only if there's not a registered agent. So as sort of a cheeky answer to your question, a banker should not be getting a subpoena. But the typical scenario, to answer like the real question behind it, the typical scenario that a bank is subpoenaed is to obtain customer records. Typically in some sort of state court lawsuit that's going on, one of the parties wants the bank records of the other, so they will subpoena the bank as a non-party. So that is the most common instance we see. Occasionally you have criminal subpoenas where there's a criminal investigation going on and the bank is subpoenaed in that context. More recently, I've seen one from a specialty tax court where IRS counsel wanted bank records. So, but most commonly it is state court, civil litigation. The bank is a non-party. Somebody just wants to see records of a customer.
I think that's an important distinction, especially for newer bankers who have not had to be involved with the fact that their bank had ever received subpoenas. To make the distinction that this is not necessarily that the bank did anything wrong. It could turn into a legal headache. They're probably going to have to get counsel involved potentially, but it's not necessarily that the bank did anything wrong. It's maybe not even that their customer did anything wrong. It's just part of a legal process playing out. Is that fair to say?
Absolutely. Okay. I would agree with that. More often than not, it's merely just a discovery tool to get records. Okay. Occasionally, rarely, could something turn into some sort of issue where the party realizes they have a claim against the bank. But that is few and far in between. More often than not, subpoenas aren't that scary. They're just a discovery tool to obtain a record.
I love how you put that to kind of take the fear out of it for people who are not used to working on the legal side of things, a discovery tool. I'm gonna file that away to use for our bankers as well.
Good.
So segueing a little bit into this concept, subpoenas are legal in nature. We all know that. But it can be difficult for banks to interpret and handle that sometimes. They're used to regulations, documentation over on the banking side of things. Here at Compliance Alliance, we always advise bankers they should check with their legal counsel for questions on subpoenas. But with that said, if a banker is reviewing a subpoena themselves for whatever reason, maybe it's part of their job duties or they're at a small bank that doesn't have in-house counsel, what are some of the major areas they need to review, and or what are some of the stumbling blocks they need to be aware of where they would need to for sure loop in counsel?
So I agree with you wholeheartedly. I cannot emphasize enough, get that subpoena over to legal.
Yep.
Really, a banker should not be processing a subpoena or responding to a subpoena without it having gone to legal first,
Okay.
right?
Yep.
So just please get that over to legal. If you don't have a contact with legal for one reason or another, I'm sure that's not customary, get it to your supervisor, right? So bankers should not be handling them, but a couple of things to keep in mind about subpoenas. Depending on the type of subpoena, the banker might be obligated to act a certain way. So for instance, with a grand jury subpoena, in Texas, grand jury subpoenas are to be kept secret, right?
Okay. Mm-hmm.
So that banker cannot disclose the existence of that subpoena to their customer, right? And this is the person who they have a relationship with.
Yep.
They speak with frequently, possibly. And so if you see that it's a grand jury subpoena that you've received, zip those lips.
Yep.
Do not say anything about it other than to bank legal or other bank personnel that are required in the processing of that grand jury subpoena. So that's an important thing to keep in mind if the banker happens to be the one that receives the grand jury subpoena.
Okay.
And then I guess something else to sort of keep in mind is that subpoenas are part of a legal process. They require strict adherence to procedural rules.
Mm-hmm.
And if the bank hasn't ensured that that subpoena sort of checks all the boxes of those procedural rules and statutes, and then it just discloses the information, then the bank could suffer some consequences there. So better, as you said, and as we both said, get it over to legal and let them handle it.
So to build on what I just said, receiving a subpoena does not mean the bank has done anything wrong, but in handling a subpoena, a bank could do something wrong. Is that fair to say? And I do think that's why bankers get nervous about this, because this is a serious document to understand how to handle or how not to handle, and to pass on to your supervisor and make sure that it goes to the right process. So in terms of, with the caveat that we always say go to legal, out of curiosity for bankers who faithfully hand their subpoenas over to legal, just out of our curiosity, can you describe your action plan when you are working through a subpoena, when you're working on behalf of a bank? They've gone through the motions, they've looped you in. Just out of curiosity, what's the workflow on that?
So it's very much like a flow chart, right?
Okay. Yep.
Let me take it back a little bit. When I receive a subpoena and it comes across my desk, typically it's already gone through some processing with internal legal. So they have a very specific question because they know how to process these generally. And if they're looping me in, that means there's something already iffy about this thing. Okay. And so it really directs my attention on how to process this. But say internal legal sends me a subpoena and they say, can you take a look at this and tell us about it? Well, my flow chart then would be first determine the type of subpoena and the type of legal proceeding from which it originates. So you have a different set of rules that apply if it's a state court subpoena or a federal subpoena or a specialty tax court subpoena. You have a different set of rules if it's from a governmental agency or a private party, right? And so by determining the type of subpoena, criminal or civil, I will then sort of access the rules of procedure that are applicable to that, and I will be able to use those rules while I'm analyzing the subpoena to make sure it ticks off all the boxes, right?
Okay.
So that's my first step. And then I make sure that the content is correct, the form is correct, that it was served correctly, that it adheres to the geographical limitations of a subpoena,
Okay.
right?
Mm-hmm.
And then in terms of what is being commanded of the bank, right? So not every subpoena includes a document request. It might be a subpoena for the bank to appear and testify, right? Which
Okay.
might
Yep.
involve a different sort of response,
Yep.
typically a motion for protective order, or me calling the requesting party's counsel and saying, can't you just take a business records affidavit? But more often than not, it does include a document request. So then I have to go through and make sure those document requests, if they're for records of a customer, make sure that the subpoena is compliant with all the rules regarding that. If it's for bank policies and procedures,
Okay.
then object and protect the bank. Under Texas law, the bank does not have to give those out. Not typically. It would be really rare for that to occur. I think that answers your question. That's sort of my flow chart. And really, it's all with an eye toward determining, do I need to file objections to the subpoena? Do I need to file some sort of motion for protection, or something like that?
I really appreciate that you shared that, because I think it gives us a peeling back the curtain viewpoint for those of us who come from a banking background like me. So I'm not an attorney, I'm a banker. I certainly respect the legal process. I'm certainly one who has said, send that to legal. I don't want to touch it. I'm not going to, give input on it. But to know kind of how you process something kind of just makes it more understandable to me, but also drives home to me why you need to send it to legal, because those are fairly complex questions that someone, with your training and licensing needs to work through. I wouldn't want to be the banker working through that. I don't want to take that responsibility to try to understand the document in front of me. So with that said, do you have any actual stories? And don't tell us details. I'm not trying to ask for anything actual, personal. Keep everything confidential. But do you have any real life examples of when bankers handled, or maybe even made a mistake and mishandled a subpoena, where you had to come in and kind of help fix or correct something because a banker did make a mistake or make an error before it got to your desk?
So I'm happy to say I don't really have that many of those particular
I
war
love it.
stories.
I
Yeah.
love it. I'm glad to hear
Um, more often than not, the problems with any subpoena come
that.
from the requesting party and their
Okay.
failure to comply with the law, right?
Okay.
So that's the fight I have most often. There's only one occasion that I can think of where something was mishandled,
Okay.
and it involved actually a banker that was
Okay.
given a subpoena. So already it's wrong, right?
Yeah.
But
Yeah.
the banker sort of set it aside and forgot about it.
Didn't really want to deal with that. Put it on the unhappy mail stack and out of sight, out of mind.
Right. And so the bank wasn't truly aware of it until a motion to compel was filed by the requesting party, right? So
Wow.
at that
Okay.
point, it seems like the bank's already in hot water. What are you going to do? So it comes to me,
Okay.
and I just contact the requesting party's counsel. I explain the situation, and they were smart enough to say, okay, I'll withdraw it, and I'll withdraw my motion to compel, and I'll send you a new one. They were understanding. And so no real harm done, right? And I hesitate to say this next part, because the takeaway here, the only takeaway, as I'm sure you will appreciate, is send it to legal. Immediately send it to legal.
Yeah.
But in actuality, if they had really gone down on that motion to compel, they would have lost. I mean, they did not serve the subpoena correctly.
Okay. Yeah.
It did not comply with the Texas Finance Code 59.006, which is the exclusive method of compelled discovery
Okay.
in Texas.
Mm-hmm.
And so when a subpoena does not comply with that statute, Texas case law says it's invalid.
Okay.
And the bank was never obligated to comply with it, right? So they couldn't win on a motion to compel. Ultimately, no harm done. Still, though, we would rather process those on the front end and be compliant,
Yeah.
within the time frame of the subpoena itself, rather than learning months later that it had just been sitting there and was never processed.
It sounds like a lot of headache for everyone, and I'm glad you got a good outcome for the bank. But it kind of sounds like, if I can maybe extrapolate a little bit, maybe the banker got scared and didn't know what to do and ignored it, because, as you said, the banker should not actually have received it.
No, certainly not.
But as a
It had
word to the
nothing
wise,
to do with that
if a
banker. It's
banker ever
simply a
receives
request
it,
for customer
give it
record.
to your supervisor, give it
Yeah.
to your legal. Like, don't try to hide it or ignore it or lose sleep over it yourself. Pass it on up the chain, because you probably shouldn't have gotten it yourself anyway. That makes a lot of sense to me. Yep.
Exactly. So if I may, I can share a couple of war stories that
We want to hear
involve
them, Sarah.
the requesting party messing
Yeah.
up, which is what happens more often than not.
Okay.
So recently I received a subpoena. It came across my desk, and the bank had asked me to review it because it contained 19 requests for production, which is
Okay.
unusual.
Mm-hmm.
Typically, if somebody is seeking customer records, it has one or two requests. They want account statements, signature cards, account agreements, that sort of thing, right?
Mm-hmm.
But this was 19 requests. And also, they weren't sure that it had complied with the notice requirements to obtain the customer records, and all of that's set forth in the statute.
Mm-hmm.
So I was taking a look at it, and this is actually a subpoena that came from a vendor that is used by the requesting party's law firm. So I don't know if you know about this, but some firms will send out subpoenas themselves. They'll draft it all entirely and they will issue it. Some firms have such high volume that they use vendors whose
Yep.
business it is to make sure they send out compliant subpoenas.
Sure.
So typically, if you get a subpoena that comes from a vendor like Lexitas is one that comes to mind, they know about the finance code. They know what boxes to check. And so I'm looking at this, and the subpoena says to respond anytime after 24 days, which is not a date certain, right? Indefinitely, I could have that subpoena on my desk, and 5 years from now, if I decide to respond, then I'm compliant, right?
Anytime after 24 days.
It was just shocking to me because that's one of the most basic
Yep.
requirements of the Texas Rules of Civil Procedure. It applies to all types of
Yep.
subpoenas, not just to banks, right? It's
Yep.
Rule 176. You have to have a date for compliance. And so right there on that little small thing, this is an invalid subpoena, right?
Okay.
But then as I dug deeper, because this requires attention to detail, right? And we want to make sure we catch every problem with this. Buried in the very last request for production, they asked for all suspicious activity reports.
No, they asked for SARS?
Yes.
No.
And any
Even I
communication
know that's a
regarding
problem.
SARS, anything maybe tangentially related to SARS. It was so overbroad. And I could just tell they had no clue what they were doing. They had never subpoenaed bank records before, because if they had, they would know that that is extremely protected.
Yep.
It's the most privileged. A bank
Yep.
doesn't even have to disclose the names of personnel that may even work related to SARS,
Yep.
right? So
Yep.
I immediately called counsel and told them, look, I can file something with the court, but in actuality, you should withdraw the subpoena and amend it, because it's so bad. It makes you look so bad. And so a lot of what I do is actually educating the attorneys of the requesting party, because you would be surprised at how many civil litigators just are completely oblivious to Texas Finance Code 59.006 and the unique process for getting records from a bank.
That is
So
fascinating. I think a lot of us forget that even educated professionals who know what they're doing may not know what they're doing in an area that they're not used to.
yes.
So, and to put that kindly, so even someone who is truly representing another party and would have a right to prepare a subpoena, it doesn't mean that they have correctly prepared the subpoena. Is that kind of what I'm hearing?
Oh, definitely. That's exactly right.
You're always going to have folks who don't know what they're doing. But yeah, as soon as you said the suspicious activity reports, I was like, hey, I'm a banker. Even I know that one.
Yeah, your face,
Any
your
GSA
jaw
officer
dropped.
worth their salt is going to know the rules surrounding that. So thank you for sharing that real life anecdote. I hope that's enough to give a little bit of levity to people who are concerned about subpoenas. Because what we do hear from bankers in my area of work is that this is an area that causes headaches and stress to bankers. I'm sure when they're able to work with, an attorney like yourself, I'm sure you put people at ease, which is why you should get your legal involved, because that is a way to just lower your blood pressure and let it go more smoothly. Um, in terms, again, of the banking side of things, how would you help bankers understand the difference between a subpoena and a garnishment? Because we do hear from bankers sometimes there are two types of orders that a bank can receive. And bankers sometimes confuse them, even though they're very different types of documents.
Yes, I would say the similarities between those two documents pretty much end at the fact that they're both procedurally intensive,
Yeah.
and that you should send them to legal.
Yeah. Fair enough.
I'm just going to beat that drum.
Yeah.
Like I mentioned, a subpoena is a discovery tool to obtain records or testimony from a certain party. In the garnishment context, that's a legal process where a creditor can sort of indirectly collect on, more often than not, a judgment that they're owed,
Mm-hmm.
right? And so they have to follow a certain legal framework. They file a petition, they obtain a writ that gets served on the bank. And basically what they're doing is they're saying, hey, bank, this person owes me money pursuant to this judgment,
Mm-hmm.
and you owe them money because they have accounts at your bank.
Mm-hmm.
Give me that money.
Mm-hmm.
So, like I said, it's an indirect way for them to get their debt paid, right?
Yep.
Through
Yep.
a third party.
Yep.
Lots of rules apply to this. It's very procedurally intensive. A big body of law behind it as well, but they are vastly different processes,
Mm-hmm.
right?
Mm-hmm.
One area you're trying to obtain documents or testimony,
Mm-hmm.
in the other area you're trying to get paid for a debt. And then I would say there's probably a third type of order that bankers see that
Mm-hmm.
sort of spans the gap between subpoenas and garnishments as well, and that would be receiverships.
I appreciate that you brought that up. I appreciate that. Yeah, tell us more.
Sure. So a receiver will be appointed generally in a post-judgment context, like a
Mm-hmm.
garnishment,
Mm-hmm.
where the judgment creditor is seeking to satisfy the judgment they have against a certain debtor. And
Mm-hmm.
they've been unable to collect so far, right? So they're saying, hey, receiver, help me out. The
Mm-hmm.
receiver gets appointed via what's called an order appointing receiver, and that order gives them all sorts of powers when it comes to the judgment debtor.
Okay.
And one of those powers is to require the turnover of non-exempt assets,
Okay.
including certain accounts
Mm-hmm.
held in the name of that judgment debtor, right?
Mm-hmm.
And so a receiver will send what's called a levy letter or a freeze letter with a certified copy of their order appointing receiver, and they will direct the bank, hey, bank, if you have any accounts in the name of this judgment debtor, as you'll see, I'm authorized to require you to turn those over to me. Freeze them right now, turn them over. Also, I want all sorts of documents, and my order allows me to do that as well. So it's kind of like marries the two concepts, right? Subpoenas and
Yep.
garnishments.
That makes sense.
Um,
Yep.
yeah, so a receivership is like both.
Now, I appreciate you drew that distinction, and then those receiverships that can kind of bridge, because banks they have to give something in response. Garnishment means they're going to have to give money, not the bank's own money, but the account that's holding the
Right.
money.
Yeah.
Subpoenas are usually asking for information potentially, and then you might need to give money and information. I appreciate you laid those out. I think for bankers who get nervous about any type of legal order, that distinction is important. But again, send it to legal. Let legal figure it out.
Absolutely, because there are very specific statutes that apply to receiverships, and the
Mhm.
bank can be protected
Yep.
so long as that is a certified copy of the order
Mhm.
appointing receiver, and so
Mhm.
long as the receiver actually has the authority as granted by that order, which requires some very specific legal analysis when you're processing that order. So again, definitely send it to legal, because we want the bank to be able to have and enjoy those protections for any compliance with a subpoena or a receiver's order and letter or a garnishment, right?
Do you have, so a lot of the folks who listen to the podcast do come from a banking compliance background. We are Compliance Alliance. Do you have any thoughts, broadly speaking, on compliance considerations when handling subpoenas specifically? Or is it just don't touch it, don't put it on your pile of mail on your desk, send it on to legal? Any other considerations banks needs to worry about until they then get instructions from legal counsel on any actions to take?
I really can't think of anything other than the drum I keep beating about send it to
Yeah.
legal.
Yep.
Um,
Yep.
Other than just remember that grand jury subpoenas are to be
Yep.
kept secret.
No, I think
Um,
that's a good one to remember. Yep.
and also, some orders appointing receiver
Mm-hmm.
will allow that receiver to include language in their letters saying you are not to tell the judgment debtor about this.
Okay. Okay.
So it's similar to a grand jury subpoena. That's not every order appointing receiver,
Okay.
but it's something to be mindful of
Okay.
when you see one.
So bankers are typically a fairly private, closed-mouthed people because there's a lot of privacy rules surrounding banking. But that's really important to keep in mind, is that there could be additional heightened privacy concerns, secrecy concerns with these orders. So don't talk about it until legal tells you who you can talk to about it as well, is a good takeaway I'm getting.
Yes.
Yeah. Um, Going a little bit off of that, do you have any suggestions for banks on how to help staff understand the difference between privacy limitations and legal subpoena requirements? And I feel like we probably just talked this through in what you just said, but we
Right.
do get those questions. I don't know how familiar you are with, just banking regulation. We get questions on like regulation P privacy questions constantly, which is just don't share your customers' information, in a very elementary way of putting it.
Yeah.
But what would you say in speaking to the concept of privacy concerns in relation to these types of orders?
So I would say that in my experience, every bank is sort of different in terms of the
Mm-hmm.
level of resources it dedicates to
Mm-hmm.
processing subpoenas and
Mm-hmm.
garnishments and receiverships.
Sure.
Um, I've heard of banks having just a single person that handles all of those.
Yep.
The larger banks have departments for each
Yep.
type, right?
Yep.
And so the training can really vary
Mm-hmm.
in terms of
Yep.
how intensive you are training your staff to process these things.
Yep.
Um, and then otherwise, I would just say, repeat what I've already said. Send it to legal. Legal knows what to do,
Mm-hmm.
and then also maintain secrecy until legal tells you otherwise.
Yep.
But yeah, training your staff on that part of it at the bare minimum, I think, would
Mm-hmm.
be important, and then reminding them that there are certain statutes that require
Mm-hmm.
notice to the customer. So
Mm-hmm.
honestly, scratch that. Send it to legal.
Yeah, yeah.
That's
But
my
it's
summary.
probably a good rule of thumb. So let's say we do have a banker who's on a committee or within their job function, they are aware that a subpoena has been, forwarded to legal. Not something to talk about in the break room at the bank. Not something to tell any customer that they might be affected. Just keep it to yourself. Maybe if there are certain staff members where it's appropriate that they need to be aware, but probably don't even really just discuss it with your best friend in the other cubicle. Just keep things to yourself until you know who needs to be informed about what. Is that fair to say?
Yes.
Okay. Let's just, yeah. And I do know bankers are generally extremely knowledgeable and skilled in the area, even within banks, not sharing information across department lines that should be kept private and whatever. So we're preaching to the choir on this, but I think it's probably a good reminder in terms of some of those privacy provisions.
100%.
Sarah, is there any final guidance you would give to bankers or any advice you would give to bankers? We have mentioned, you might not have noticed, we've mentioned send it to legal. But yeah, just in general, a rule of thumb or anything you can give to folks who are newer to this or just want to glean a little bit more knowledge.
So I think we covered this earlier, and you said it very well. It's nothing you really have to be that scared of. because it's typically just a document request, a tool to obtain documents or testimony, where the bank is just a non-party and is just the keeper of these records, right?
Yep.
The bank's not actually involved or in any trouble. So keep that in mind. Get it over to legal, of course. And then if you are at all involved in processing these things, to remember attention to detail is key. There's so many pitfalls when it comes to processing this because requesting party attorneys just so often don't meet their requirements. And so you have to call them on that, right? And then some overarching concepts in terms of subpoenas to anyone, but including banks, is that when you are trying to obtain records from a non-party, courts basically require the requesting party not to impose an undue burden or expense, right? It's not supposed to be super difficult for a non-party to comply with a subpoena. And then in the banking context, the statute actually allows the bank to recover its attorney's fees if it has to expend any attorney's fees. So all the more reason to send it over to legal and get legal involved, right? Because those fees are covered if legal has to do anything special in relation to that subpoena. So those are some of the overarching concepts that I like to keep in mind. And then the final one I would say is in your standard scenario where you have a state court, civil litigation, and somebody's just trying to obtain customer records. Notice to that customer is key because that customer deserves an opportunity to object and protect their records if they want to. The statute actually imposes the burden on the customer to prevent the bank's compliance, right? But the customer can't do that if they haven't received notice of it, if they're just completely unaware. And so there is a very strict framework in the statute for making sure that has happened. And so in that particular context, making sure the customer had notice is key, which I know that can get confusing if you're not immersed in this on the daily. So to differentiate between grand jury subpoenas, secret, state court civil litigation, customer should have received notice, but that's the requesting party's burden. So.
No, I think that that's a really good distinction as well. And again, just to drive the point home, that's why you need some legal guidance on this. So you need to wait till legal tells you what to do, and then you need to do it. Because either it's absolutely don't inform anyone, or these certain people, like the affected party, needs to be informed so that they then can assert their right or object or whatever their action may be. Sarah, I appreciate this so much that you have broken down into plain terms things that can be very confusing or a little bit scary for bankers. You've given your time and your just knowledge to us, and I appreciate it very much. Any final words you'd like to say as we wrap up the episode?
I think that's about it. If you have any issues with a subpoena, feel free to give me a call.
Well, thank you so much for sharing your time. It has truly been a pleasure to chat for the last 30 minutes. Sarah A. Samuel has been our guest on this episode. We appreciate your time, and I look forward to talking again. And then until next time, this has been Banking Matters, and I'm Elizabeth Holtrop.